The ICCBA has long attempted to sensitize the registry of the ICC to the importance of legal representation of victims at the early stages of the proceedings. We believe that such representation is crucial, not only for the well-being of victims in interacting with a foreign judicial system, but that early representation also benefits the legal proceedings themselves. In the last year, in addition to our very active Victims Committee, the ICCBA created a working group dedicated to the issue of victims in the early stages of the proceedings, and has also prepared a draft protocol on services for LRVs in early stages, which is currently being discussed with the registry. Such protocol could help us better define the role of LRVs in the early stages, and above all, achieve a better recognition of their role. Now, with that said, I have the privilege of introducing the keynote speaker, Judge Elizabeth Odio Benito.
Amigas y amigos, quiero darles a todas y a todos las gracias por haberme invitado a participar en este convivio, en esta reunión que es tan importante para los temas fundamentales de la Corte Penal Internacional y del Estatuto de Roma. Muy agradecida quedo con todas y todos ustedes porque me permite ayudarles con algunas reflexiones a recordar momentos fundamentales que no podemos perder de vista y que no podemos dejar atrás en la lucha que sigue adelante. Cuando el 17 de julio de 1998, prácticamente a la hora 25, se aprobó el Estatuto de Roma, miles y miles de miembros y miembros de la sociedad civil explotaron de júbilo y alegría junto con una buena cantidad de estados que habían trabajado arduamente. Se habían incluido en un estatuto por primera vez en la historia del derecho internacional crímenes de guerra, crímenes de lesa humanidad y genocidios contemplando la violencia sexual. Se había incluido la perspectiva de género y algo fundamental, se habían incluido los derechos de las víctimas. Las víctimas de esos crímenes, las víctimas históricas de los horrores de todas las guerras, estaban por fin reconocidas como sujetos fundamentales en el accionar de la futura Corte. ¿Por qué es tan importante la participación de las víctimas? Porque sabemos que sin la participación de las víctimas, las investigaciones no están completas. Eso es lo que nos pasaba en los tribunales ad hoc. Las investigaciones no se completaban. No se hablaba de crímenes de violencia sexual, por ejemplo, porque las investigaciones jamás estarán completas si las víctimas no participan desde el principio. Tienen que dársele a las víctimas todas las oportunidades, todos los espacios, toda la importancia que deben tener. Tienen que dárseles la oportunidad de crear una narrativa empoderadora y devolverles a las víctimas su autonomía y su sentido de sí mismas. Las víctimas y los sobrevivientes son parte esencial y la razón de existir de organismos como la Corte Penal Internacional. Como les decía, sin ellas no hay ni credibilidad ni legitimidad para que las víctimas puedan acudir a la Corte. Son evidentes. El acceso a la información. Si las víctimas no están informadas por las remotidades donde muchas de ellas viven porque ahí ocurrieron crímenes atroces, si no hay adecuada información, las víctimas no podrán enterarse y no podrán participar. Por eso el acceso a la información es muy importante. La distancia entre la sede de la Corte Penal en La Haya, donde ustedes se encuentran en este momento, y las víctimas es también algo que hemos sentido siempre. Y la falta de acceso a la representación legal adecuada es fundamental, porque sabemos que las víctimas pueden ser cientos o miles. Y sabemos que hay, la Oficina de Víctimas y Testigos de la Corte en la Secretaría lo ha organizado a través de la representación legal. Tenemos que organizar que las víctimas tengan la representación legal adecuada para que tengan quien las represente, aunque no puedan estar presentes todas físicamente, porque es imposible, pero no pueden quedarse fuera. La falta de procesos centrados en las víctimas, esto es un punto muy importante. Es un punto muy importante para el futuro de la Corte. Esto lo aprendí de primera mano en mis años en la Corte Interamericana de Derechos Humanos. Los derechos humanos están centrados en las víctimas, están centrados en quien sufre los horrores que se cometen cuando se cometen crímenes de lesa humanidad, o se cometen genocidios, o se irrespetan los derechos humanos. Son las víctimas, el centro mismo del accionar de los derechos humanos en la Corte Interamericana de Derechos Humanos. Es el accionar fundamental de esta Corte. Y esto falta todavía en la Corte Penal Internacional. Faltan los procesos centrados en las víctimas. Hacia eso hay que avanzar. Nos hace falta también en la Corte personal especializado. Lo sabíamos desde el principio, cuando hablábamos de investigadores que les daba vergüenza hablar con las víctimas de delitos sexuales. Falta personal especializado. Falta gente que sepa en qué consisten los crímenes de género y la perspectiva de género. Esto falta, este entrenamiento se nos ha ido quedando atrás en los últimos procesos en la Corte, por lo que he podido enterarme. Obviamente, hay obstáculos importantísimos que son barreras lingüísticas y culturales. Falta de recursos asignados a las oficinas de la Corte encargadas de promover y facilitar los derechos de las víctimas. Si al hacer el presupuesto de la Corte se deja de lado la importancia de las víctimas y de las oficinas de las víctimas, y no se les da a las oficinas de la Secretaría de la Corte los recursos suficientes para que las víctimas tengan acceso a todos los derechos que el Estatuto les da, no estaremos cumpliendo con la credibilidad y la legitimidad de la Corte. Y por supuesto, la importancia de la representación legal de las víctimas no puede quedársenos atrás. Quiero concluir con algunas recomendaciones que se me han ocurrido de la importancia de las víctimas en todo lo que es el accionar de la Corte Penal Internacional. Recomendaciones. En el trabajo que ustedes van a hacer ahora, ¿qué pueden recomendar ustedes a la Corte? ¿Qué pueden recomendar ustedes en su cercanía con los jueces? Los jueces de la Corte deben procurar ampliar las posibilidades y los espacios de participación para las víctimas en las etapas iniciales del proceso, porque esto puede ayudar a empoderar a las víctimas, quienes en realidad son las dueñas de su proceso judicial, así como quienes pueden aportar la información relevante y fundamental para la investigación y la creación de los potenciales casos. ¿Qué casos vamos a tener si no tenemos la participación de las víctimas y la información que ellas pueden suministrarnos? Una vez que se incrementan los espacios de participación para las víctimas, estos espacios deben contener amplios plazos. Esto es muy importante, que las víctimas tengan plazos, tiempos suficientes, que ahora no se les da. Quien tiene más espacios son los jueces, son fiscales, pero a las víctimas se les dan muy pocos tiempos para que puedan participar, para que puedan aportar sus puntos de vista y las pruebas que las propias víctimas pueden aportar. La Corte tiene una oportunidad para abrir campos y caminos mediante la creación de la jurisprudencia que garantice la participación efectiva de las víctimas. Estar cerrando la jurisprudencia, como hemos con mucho pesar notado, que se está cerrando la jurisprudencia de la Corte, de los jueces que no le están dando a las víctimas los espacios y la importancia que las víctimas tienen en las sentencias, es realmente acabar de alguna manera con la justicia, con la legitimidad, con la impunidad de la Corte. Y esto creo que en un foro como el que ustedes van a llevar a cabo en los próximos días, es fundamental que ustedes lo hagan llegar a los jueces. Hay que fomentar que el personal dedicado a los temas de víctimas le den a la Corte y tenga la experiencia y las cualidades y la formación adecuada. No es cualquiera el que puede trabajar con víctimas, no es cualquier abogado, no es cualquier juez, no es cualquiera psicóloga. Tiene que ser personal especializado, hay que tener una empatía que hemos ido perdiendo con las víctimas. Esa empatía es esencial. Y finalmente, quisiera mencionar algo que para mí siempre fue muy importante, el papel de los estados. Los estados miembros del Estatuto de Roma tienen que asumir una responsabilidad que poco a poco han ido dejando de lado. Hay varios espacios en que los estados tienen que colaborar con la Corte. Uno de ellos, obviamente, podría ser la reubicación de las víctimas. Que haya posibilidad para proteger las víctimas, de que los estados abran espacios para reubicar víctimas. Pero además, para todo lo que tiene que ver con las reparaciones. El papel de las víctimas en las reparaciones, en la Corte, es fundamental y lo están dejando por fuera, lamentablemente. ¿Quiénes, si no las víctimas, van a poder decir exactamente qué necesitan para que su proceso de sanación sea posible? Para que puedan recuperar sus vidas, para que puedan rehacer sus vidas y seguir adelante. Es a través del proceso de reparaciones. Las reparaciones fueron incluidas en el artículo 75 del Estatuto precisamente por la experiencia que se tenía ya en la Corte Interamericana de Derechos Humanos de lo que significan las reparaciones para las víctimas. Sin ese proceso de reparaciones, las víctimas no van a poder seguir adelante y los estados son muy importantes. La Corte no tiene más que el fondo fiduciario. Los acusados que resulten sentenciados ya sabemos que o habrán ocultado sus recursos o no los tienen. Entonces ahí es donde los estados pueden, desde sus propias legislaciones, acudir en ayuda de la Corte en las reparaciones de las víctimas. Son ideas muy apretadas, son experiencias que he mezclado de los tribunales ad hoc, de mis años en la Corte, de mis años en la Corte Penal, en la Corte Penal Internacional y de la Corte Interamericana de Derechos Humanos. Son todo un mundo de justicia que fue pensado para las víctimas. Y eso es lo que hoy quiero reiterarles a ustedes, amigas y amigos. Muchas gracias.
After those very moving opening remarks by Judge Odia Benito, I think it is really, it really sets the stage and the tone for our discussions today. To refer to what she said, that without including victims in proceedings, justice is not complete. She spoke about amplifying, widening, opening the space for victims to participate at every stage of the proceedings. And we are concerned today with looking at their participation from the earliest stage, because that seems to be where there is quite some controversy in terms of the scope of their participation. And that is what we'll explore in this panel. So I'll start with you, Gilbert. Judge Odia Benito set the stage, I think, for us, but I think it would be really important for you to outline for us in a little bit more detail the legal framework and scope for victim participation at the earliest stages of ICC proceedings.
I will be responding to your question also in two parts, because I think we are speaking about many things. And I think the first thing is that we need to define the terms. What are we speaking about? So I will have a part one on definition of terms and a part two on victims' participation. You cut me whenever you think I've been speaking too long, because that's the best. Alors, you spoke about victim participation at the situation. What is a situation and what is a case? And I think that as long as we don't define that, we don't really understand where are the problems and what are we talking about. So what is a situation? A situation is a set of facts in a territory during a certain period of time. That's what a situation is. This period of time is not necessarily defined a priori. So, for example, when we speak about the situation in DRC since 2002, the situation of which the ICC was seized in 2004 extended well beyond 2002 and may still be ongoing for years. And that's the problem of the situation, is that it can extend and you don't have a priori the extent. You cannot define a priori what will be the extent of that situation. A situation, as you said, entails in fact two stages of the proceedings: the preliminary examination and the investigation. The investigation, and that's interesting, will go on. So I often present the investigation as the mother and the cases as the daughters. The mother will go on even if it produces some daughters, so some cases. It will go on, you will have the investigation in parallel with the cases. What are cases as opposed to the situation? The cases comprise specific incidents during which one or more crimes within the jurisdiction of the court seem to have been committed by one or more identified suspect, and entail proceedings that take place after the issuance of a warrant of arrest or a summons to appear under Article 58 of the Rome Statute. A case is a subset of fact taken from the situation. And then I'm going to start now to underline what is so important in this distinction and this definition of terms for the victims, because everything is there. The case is always chosen by the office of the prosecutor, whereas the situation may be referred and defined by a state party or the Security Council, not the case. And the problem of the case is that it may be infinitely smaller than the set of facts of the situation. Just compare the first situation and the first case in the history of this institution. And then you will understand what is the problem of the victims of the situation. The first situation is the situation in DRC. That's a big country. The first case is the case of Lubanga. What is the case of Lubanga about? It's facts which only occurred in Ituri, which is one of the 21 provinces of the DRC. First limitation. It's only facts committed by the UPC, Union des Patriotes Congolais, which was only one of the many groups which were active at the time in the DRC, without taking into consideration, of course, that the fact that states were also quite active in the DRC at that time. So it's only one group. Second limitation. It's only for 1 year, 2002, 2003. Third limitation. Fourth limitation, it's only conscripting or enlisting children under the age of 15 into armed forces or groups, or using them to participate actively in hostilities, which, by the way, put aside in that first case all the sexual crimes and all the murders. So you have an extremely limited case within a huge situation. The result is what? You have a very small group of victims who are the victims chosen by the office of the prosecutor as a result of the selection of cases by the office of the prosecutor. And you have a very big group of victims, the victims of the situation, the victims of the facts outside of the case, who are the victims not chosen by the office of the prosecutor. And everything is about that. Is depending on the choice of the office of the prosecutor for the cases, the immense majority of the victims may be left out from the cases, especially if those cases are not in any way representative of the victimization in that situation. This is the definition of terms, and I think we need to understand that, because then when we will go at one point to what is the reaction of the office of the prosecutor towards the victim of the situation, but then you understand what is the reaction of the office of the prosecutor. It's simply because he does not want to see the victims of the situation, because these are the victims that he didn't choose. It would be much easier for him to accept the victims of the case, because these are the cases chosen by the office of the prosecutor. And those victims are simply going to basically back what the prosecutor is going to do most of the time in those cases. Whereas for the others, but the OTP does not want to see them. Second part, the participation of victims. You have 4 articles in the Rome Statute about the participation of victims: 15, 19, 68, 3, 75. I will put 75 on reparations aside, but it's a very important article. Why? Because it justifies the interest of the victims to participate at early stage of the proceedings. This has already been said by the pretrial chambers. Why? Because if you don't have an investigation, you don't have reparations for victims. If you don't have cases, you don't have reparations for victims. So there is a direct interest for victims to participate at the early stages in order actually to have an investigation. Because if they don't have an investigation, they will not get any reparations. Then the main article is Article 68.3, although it's not the only article allowing victims to participate at the early stages of the proceedings. For example, Article 15 and 19 has already been used to allow victims to participate at very early stages of the proceedings. So you cannot say that the statute as such does not even envisage the participation of victims of the situation, or at very early stages of the proceedings, because this is what is done under Article 15 at the moment the prosecutor wants to open an investigation. But why is it easy for the prosecutor to accept Article 15 and much less 68.3? For a very simple reason, is that at that time the prosecutor has decided to open an investigation. So the victims are going to come in support of the request of the prosecutor to open an investigation. When victims are going to come under 68.3 eventually to challenge what the prosecutor is not doing, then the prosecutor is not happy at all, because actually the victims are going to underline that there are some things that he didn't do, and that maybe it is not very clear why he doesn't do some things. Article 68.3 composed of two sentences. The first one says, where the personal interests of the victims are affected, the court shall permit their views and concerns to be presented and considered at stages of the proceedings determined to be appropriate. Okay. And then there is, in a manner which is not prejudicial or inconsistent with the rights of the accused. Second sentence, such views and concerns may be presented by the legal representatives of the victims. Why is 68.3 so important? 68.3 speaks about appropriate stages of the proceedings. 68.3 is an undefined article because we didn't reach at that time the stage basically of discussing what does that mean, the appropriate stages. It is not, it's simply an open article, and the rules applying that article are as open as the article. Therefore, victims have, at least it is possible for victims to participate in all stages of the proceedings. It is as simple as that. The OTP never wanted the victims to participate. At the very beginning, because I know that because I was there, the position of the OTP has been that the victims should participate whenever they support the office of the prosecutor. That's as crystal clear as that. Whenever the victims come to complain or to ask for something that the OTP is not asking, they don't want to see any victim. That's why they hate the victims of the situation, because as I have explained, the victims of the situation are all the victims who are out of the cases chosen by the office of the prosecutor. And the office of the prosecutor has always been against the possibility of victims to participate within the context of the situation, and especially at the stage of the investigation. There has been a lot of jurisprudence on that. Why? Because they underline what the prosecutor is not doing. It's as simple as that. If you allow the victims of the situation to come before the judges, that allows victims to simply say, but why did the prosecutor choose that case and not the other one? Why is the prosecutor concentrating on the child soldiers in Ituri and he completely forgets the murders and the rapes in the Kivus? Well, the office of the prosecutor does not want to answer those questions. Unfortunately, the pretrial judges have not been very favorable to answer also to the victims about that. And I think that this is a real problem for the legitimacy and credibility of this institution. You need to have a real check on what the prosecutor is doing and not doing. And you cannot discuss with the office of the prosecutor on that. You have to impose that on him. But if it is for its benefit, because I think at the end of the day, it would really increase the legitimacy and, as Judge Odio Benito said, and the credibility of this institution. There is, to a certain extent, an agreement between judges that the victims should be able to participate within the situation. I don't have the time, but there was a big fight in 2006, 2009 between the pretrial chambers and the appeals chamber, which was solved, I think, to a certain way by paragraph 56 of the decision of 19 September 2008 by the appeals chamber, when it was said, it must be clarified that victims are not precluded from seeking participation in any judicial proceedings, including proceedings affecting investigation. The appeals chamber did something at that time which I didn't like. Until today, I think that they are wrong. But what is good for the appeals chamber is that nobody has to follow its jurisprudence in accordance with Article 21.2. Not even the appeals chamber itself. They can change their own jurisprudence. And that I think is absolutely good. What the appeals chamber said is that victims can only participate in judicial proceedings. No, Article 68.3 doesn't speak about judicial proceedings. Article 68.3 speaks about proceedings. Proceedings, I have sometimes to remember that to my colleagues from common law, come from Latin, the word procedere, which means to make progress. The investigation in many countries is as part as the proceedings as any other aspect of the criminal proceedings. So that was a very particular interpretation of the appeals chamber at that time to exclude the investigation from the definition of proceedings. I completely disagree with the appeals chamber on that part. But to answer to your question on the office of the prosecutor, this is a constant position from the office of the prosecutor, and the office of the prosecutor has to be reminded that they are not first the only organ in this court, and second, that they have to make space for the victims, whether they like it or not.
Jimena, I know it's difficult to follow Gilbert, but in your own right, you have had some very direct and practical challenges in your own experience of seeking to ensure victim participation at the preliminary examination stage and further in the earlier stages. Can you share some of that experience with us?
I work on Latin America, and I remember when I joined FIDH, as Gilbert was speaking about history, just when I joined FIDH in 2003, it was just the beginning of the ICC, and my colleagues that had attended the negotiation, we were discussing what role we could have as an NGO, and we had decided that the two cases that probably would move forward would be Colombia and DRC. And I was in charge of Colombia, and my colleague from the African desk was in charge of DRC, and obviously the path of those two situations did not exactly go the same way. And that's why I would like to share with you maybe the experience on Colombia and maybe a little mention of Mexico at the very earliest stage of preliminary examination, because as Judge Odio Benito say, as Gilbert said, victims' participation should start as early as preliminary examination starts. But at the same time, compared to the investigation phase or even the cases, the modes of implementation of the right of victims remains relatively vague. And also depends a lot on how pretrial chambers interpret their mandate to monitor the OTP actions or inaction. So to speak about the obstacles and opportunities, I want to mention the closing of the 17-year-long preliminary examination on Colombia that occurred in October 2021. It was announced by the OTP through a press release with very little information on the reason of the closing. And as I mentioned, at FIDH since 2003, with our member organization, El Cajad, we had worked on capacity building, but also on documentation, and we had sent to the OTP 12 communication on international crimes committed in Colombia and on complementarity all through those 17 years. For example, we had been working with families of falsos positivos. More than 6,000 civilians were killed by the armed forces and then dressed up as guerrilla members so that they would raise the figures of guerrilla killed in combat. And the information we sent to the OTP contributed to the very important interim report that the OTP published in 2011 on Colombia. But that's another story. I won't go into that. But let's say that after the announcement in 2021 of the closing victims with whom we had worked, and local lawyers were surprised and affected by this decision, because there were still many obstacles to the most responsible international crimes being investigated or judged, and also because the closing was announced 5 months before the presidential elections in Colombia, and no one knew what was going to happen next in Colombia, because we have to remember that at the time of where the closing was announced, President Duque had been doing the maximum he could to prevent the efficient functioning of the special jurisdiction for peace. So we decided in representation of family of victims of falsos positivos to submit a request to review the decision of closing the preliminary examination. And the pretrial chamber gave a standing, but it decided in a decision of July 2022 to reject our main request, which was to review and reverse the prosecutor's decision to close the preliminary examination of Colombia. However, and that's the interesting part also for colleague, he did accept that the information provided by the prosecutor in closing the preliminary examination, which, as I said, was communicated via a press release and a cooperation agreement with the government, did not constitute sufficient information on the reason for the closure. In particular, it's mentioned in light of the length of the preliminary examination and of the expectation it may have raised for those who provided information prior to or during the preliminary examination. So on this basis, the pretrial chamber urged the OTP to promptly provide additional information on the reason of his decision to close the preliminary examination. The report was published a year later by the OTP, and it was sent to all the lawyers or NGOs and victims that had contributed to this preliminary examination, and it was also made public. Sadly, in the public version, no mention was made of the pretrial chamber order. And when the prosecutor came to Colombia a couple of weeks ago, there was no meeting or formal presentation of the content of this report. That would have been very helpful in order to move positive complementarity. Just very quickly on Mexico and this stage of preliminary examination. So. Maybe some of you, most of you know that right now Mexico is going through a huge crisis with more than 100,000 persons that have been victims of enforced disappearances since 2006, 250,000 persons that have been killed. Just in the last 6 or 7 years, 5,000 mass graves have been found. And among those crimes, we believe that crimes against humanity have been committed, in particular by organized crime with the complicity of public forces. And here again, since 2014, with many, and one of our communication was signed by 100 human rights NGOs. We have been sending information to the OTP. The last one was on the two largest clandestine mass graves in Latin America, Colina Santa Fe, with 300 bodies, and Arbolillo with 310 bodies on the state of Veracruz. And we have worked on many states. I won't go into details, but there we are a bit in a limbo with the victims of Mexico, because it's not clear. I mean, at some point, the report that used to be published, and it was very useful, the reports on preliminary examination mentioned that Mexico was in phase 1. Fatou Bensouda, in a public conference, said before a couple of months before leaving, I'm going to give an answer before I leave on Mexico. Still waiting. So there is this limbo situation, and not having something to grab to in order to be able to act. I mean, there is a need here also for, again, information and greater information and clearance for those victims that are waiting. There's 98% of impunity in that country. Just to give 2 examples of issues that are at the level of preliminary examination and how it had been dealt with. Thank you.
Thank you very much, Jimena. I do want to come back very quickly on something that you talked about. You've mentioned Mexico and Colombia. You do have, and I'll come back to you later on the Article 18 applications in relation to Venezuela. But what exactly do victims want to be involved in at this early stage? What kinds of issues? Maybe in one line, if you could.
In one line, I mean, first it's clear that they want things to move forward. And if it doesn't, they want to know why. That's on Venezuela. As you may remember, on the November 2021, the prosecution decided to open an investigation on Venezuela, and that was an excellent news for the victims. On 2022, the prosecution notified the pretrial chamber that it had received the request for the Venezuela to defer the office investigation under Article 18. And the OTP responded by requesting the pretrial chamber the authorization to continue with the investigation. So this was the beginning of the proceeding before the pretrial chamber, where judge had to examine whether it would allow OTP to continue with the investigation or not. Obviously, this issue, to continue or not with the investigation, affected the personal interest of the victims of international crimes in Venezuela. FIDH was working since 2018 on outreach on the ICC in Venezuela and on capacity building of lawyers, NGOs, victim collectives from Venezuela. The pretrial chamber instructed the VPRS to liaise with victims and their legal representative and to gather views and concerns and prepare a summary report. This approach ensured all victims interested were represented. So for those, I mean, maybe not in the room, but those that are listening and are not used to this proceeding, obviously it's critical at an early stage. And here I want to address this issue of the role of VPRS. For us, is really critical at an early stage that VPRS is given the opportunity to do an outreach work of identifying the widest group of victims as possible, their legal representative, because we are at a situation level. So together with local lawyers, we supported over 600 victims by explaining the process, including the form to be filled, the meaning. The issue of anonymity is always really key, the security measures taken by the VPRS. Then the state of Venezuela appealed the pretrial decision to authorize the continuation of the investigation. And we thought that it would follow the path of other decision, and it was going to ask again VPRS to collect views and concern. But to our surprise, the chamber issued a decision only permitting the OPCV to intervene at a hearing, not mentioning VPRS. So we decided to ask also to intervene as LRVs of victims. So the chamber there partially agreed with us, at least ordered VPRS to collect this opinion and to transmit them to the chamber, but denied to us the possibility to intervene during the hearing, allowing OPCV to do so. And here, I mean, from someone a bit exterior and also working on before the inter-American system, and in our view, is extremely important that OPCV is not the only representative of victims, and that the possibility for external representative is maintained, and victims have a choice to be able to identify their own representative, and obviously, if necessary, to have the support of OPCV. This is key. Just one last thing, because this is really key also because of this issue that Gilbert was mentioning about the scope. It is the opportunity for victims also to contribute on the necessity of having other crimes to be included on the scoping of the investigation, all the more that this will be important all the way through the proceeding.
Idea into the discussion at this stage, because we are now hearing about direct engagement with the Office of the Prosecutor. But Idea, you have also, as a legal representative, there are specific issues that you experience in terms of trying to represent victims, issues to do with securing standing at this stage. We'd love to hear from you about your own experience in the cases or in the situations that you've appeared.
When we're speaking about the work and the goals of the ICC, we often hear a reference to victim-centered justice, that victim-centered justice is not only critical to achieving justice for the victims, to addressing their harm and rebuilding their lives, but also we hear about how victim-centered justice is necessary to achieving the goals of the court. And in thinking about this discussion today, I was reminded of the different organs of the court, whether it be the Trust Fund for Victims or the state parties from the Assembly of State Parties, or even the Office of the Prosecutor, that regularly refer to the fact that justice must be victim-centered. So, when hearing these reaffirmations, I often think about whether there is also thought to how this can be practically realized during victim representation at the courts. And I'm grateful for events and conversations like this that allow us to compare notes and have frank discussion, and also look at ways to improve and continue to advance this goal of the court to center justice on the victims. As to your question on obstacles that I've experienced in my experience with representing victims to the court, I want to give two examples. One would be from the registered vessels situation, the Comoros situation regarding the Gaza Freedom Flotilla, and the second one being from the Afghanistan situation, both highlighting obstacles to victims having standing and to being heard by the court, but being approached in very different ways, which I think highlights how victims' engagement with the court and the experience that they have through their legal representatives is often very different and approached in different ways, depending on the situation, the case, the chamber. So to start with the situation, the registered vessels situation, I was a member of the legal team for victims in that situation. And just to recall the background to that, the prosecution in November 2014 had made a decision not to open an investigation into the attack on the Gaza Freedom Flotilla, which was subject to a state referral by the government of the Comoros, which is a state party to the Rome Statute. Now, Rule 92.2 states that the court shall notify victims of any decision by the prosecutor not to initiate an investigation, and that it will also allow victims to apply for participation in proceedings in accordance with Rule 89. The government of the Comoros did move forward with making an application under Article 53.3 that sought to review the prosecution's decision before the pretrial chamber. However, victims in this case were not notified of the decision of the prosecution not to open an investigation. And were also informed that they did not have standing to make submissions in the situation until the chamber had conducted a Rule 89 review of the victim applications to decide which victims could be accepted to participate before the court. The LRVs in this situation were informed by VPRS that it could not transmit the applications to the chamber for consideration under Article 89, which gives the victims the ability to participate in the proceedings, and that VPRS could not do this until the chamber had requested the applications be transmitted. And here it was raised that there was a bit of a catch-22 in this, that the chamber would have no way of knowing that the victim applications had been filed with VPRS, given that it's a situational stage of the proceedings. But in this case, our legal team was still told the chamber needed to request transmission of the application in order for Rule 89 procedure to kick in and for those applications to be considered, so that the victims might potentially be able to be recognized for participation in those Article 53 proceedings. So what transpired was that our legal team had to make a submission to the pretrial chamber, for which the victims didn't have standing, but which was filed with the chamber through a registry filing. And it was to ask the chamber to initiate that Rule 89 process so that they could request and receive the victim applications that were with VPRS, evaluate those victims for participation, and allow victims to make submissions about their interest in the proceedings, potentially, if they were approved. Here, the pretrial chamber initiated the Rule 89 proceedings at the request, so that was granted, and made decisions on victim applications, which allowed victims to participate through counsel in the Article 53.3 proceedings. It's noted that this positive decision from the pretrial chamber to allow the victims to participate and to recognize the right of victims to be a party to those proceedings, to those judicial review proceedings, might have been aided by the fact that victim participation in the context of Article 53.3 is a mandatory requirement stemming from Rule 92.2. So I'm not sure how far that extends to other instances where victims want to participate in proceedings that affect their interests. But it is an interesting point where victims were allowed to participate. And this did result in the victims participating throughout the proceedings through 3 rounds of judicial review applications and proceedings, which took place from early 2015 until late 2020. And they were able to submit their views on not only their interests, but also how the proceedings impacted them. And most importantly, to make submissions on the prosecution's analysis of the evidence. Much of which was submitted to the prosecution by the victims themselves. So they were able to make submissions about the characterization and the analysis and determination of the prosecution on that evidence. However, one thing that is notable about that pretrial chamber decision is that when the victims applied to participate, the OTP did make submissions trying to limit the participation to whether or not the investigation should be opened, and not to making any submissions on the facts or the evidence. But the pretrial chamber did confirm the victim's ability to address all issues that went to the decision of gravity, including the scale, impact, manner, and of commission of the crimes and the evidence that related to that. So I think that was quite important. Now, I want to contrast that to the other situation in which I have experience, whereby there were obstacles as well as to victim standing, and that's the situation in Afghanistan. And in this situation, the proceedings have seen very different approaches to victim participation and the standing of victims, even within the same situation from different chambers. Just to recall what's happened in that case, the appeals chamber during the Article 15 proceedings allowed the victims the right to participate in the hearings in this regard and make submissions. But this was very different during the Article 18 proceedings, which were triggered when Afghanistan exercised its right to defer the investigation for a period of time, and after events in Afghanistan changed and the OTP applied to restart the investigation, victims sought to participate in those proceedings and the determination of whether that investigation would be restarted. But here, the pretrial chamber took a much more restrictive approach to the victims and their ability to not only be recognized as victims, but also to participate as victims as well. And it resulted in victims not being able to make submissions in the Article 18 proceedings through their counsel and directly to the chamber, but rather the pretrial chamber making a decision that LRVs needed to communicate the victims' interests and any submissions they had on those proceedings through VPRS. So the submissions were made to VPRS and then collected all into one submission that was prepared by VPRS and given to the chamber. So in a lot of ways, didn't allow the victims to speak directly to the chamber and be heard on the issues they wanted to raise through their counsel, but rather through a more diluted process that compare us. So it really does highlight a two-tiered situation in the Afghanistan situation, whereby the appeals chamber has recognized the victim's ability to participate directly through their counsel, and actually did so later in the Article 18 proceedings when the prosecution appealed the pretrial chamber's decision to reopen the investigation and the scope of that decision. And then also the prosecution's request to discontinue that appeal as well. So victims were able to participate directly before the appeals chamber, but not through the pretrial chamber. Okay. And in the Afghanistan situation, we did try to highlight this before the presidency as well, but it's continued to be an issue that does deserve some recognition. So
we aim to achieve inclusive and comprehensive justice and accountability, but really with at the heart of that, by supporting the agency of victims and indeed having a trauma-informed approach so that they can meaningfully participate in justice processes, including here at the ICC. So at an event like this today, we know we often don't hear directly from victims for many reasons, and most importantly, their security, their safety and security. But we do still think, if we can, we really talked about how can we possibly hear the voice, though, of at least one victim in an active ICC situation. Because we often may hear through victims' lawyers their views and concerns about the crimes that they face, but we also need to ask, we must ask, how do they feel about the ICC more generally, the proceedings? Are they getting the right information? Are the proceedings meaningful to them at the end? And ultimately, we want to find out, how and make sure that they feel seen and heard and respected. So today we have the absolute privilege of hearing directly from a victim in an ICC situation who will share their personal experience and reflections on the ICC and its proceedings.
Human rights abuses and discriminations against Rohingya forced me to leave from my country and took shelter in Bangladesh. No, I don't think every Rohingya have this kind of possible ways to get information about the process in ICC. Most of the Rohingya I know even do not know what is really happening in ICC about Rohingya. Yes, it is very much important, and I think it will be also very much helpful for the Rohingya to keep their hopes. But at this stage, Rohingya people do not know what is really happening. That's why people are losing their hopes. People are expecting more than necessary from the ICC, something like that also. So it is ICC is very much important to know people what is really happening about the people in ICC. Obviously, because of the lacking of engagement with the people from the ICC and the lacking of enough information for the people from the court, because most of the people do not know what is the status of the case in the court and what is the court doing and what is the plan of the court to do. So it is already about 7 years. So some people already lost the hope. It is already 7 years. Maybe they are doing nothing. They even forgot our case, something like that. Yes, it is important that lawyer represent Rohingya people, because Rohingya people are not the lawyers, right? So we have not abilities fully to understand what the direction is going to where. So once we have the lawyer standing in our side to represent us, then we will understand a clear way, and we can understand what is the responsibilities and what must be our next plan regarding the case to win the case. Because always it is it's a human nature that whenever we do, not only in the Rohingya case, whenever we are in a case, then both sides want to win the case. But now, for example, Myanmar must have their own lawyer, but for Rohingya, we are not even understanding the law, and people even do not even understand the ICC. So we definitely need the lawyers so that we know things. The lawyers can explain us and represent the Rohingya peoples in a best way in the court. The proceeding of ICC is is the only hopes that the highest hope we can expect the justice from, right? And when we say ICC, it is like a wall court. There is no any other mechanisms above that. There is no any other mechanisms that can work for the justice for the Rohingya people. So it is very much important, and I believe the ICC and like another court, ICJ, can definitely have the potentials and the abilities to get justice for the Rohingya people.
So let me ask all of you the same question and then see how you'd like to answer it. Is the court actually currently providing the services that you need to do your work with victims? And if it isn't, then what impact is that having on you? Should we start with you, Isa?
Yes, thank you so much. Hello, everyone. Just to have a very short answer to that, that is no. And my colleagues and I, we are not happy with the services we receive from the court. But I can say answering to this question is not that easy. Before explaining the reasons why I said no and we are not happy with the services we receive, if there is any, let me put it there. To tell some acknowledgement, we understand that court is a young institution at the international arena, and it has ambition, goals, which is of course so needed for the humanity and for everyone. And also, court is the last resort, and it's a beacon of hope for millions of victims. And we also understand that the court is surrounded by multifaceted challenges and obstacles, political, legal, and operational. Whatever I'm going to say, it is with this intention that we want to have a stronger and a better court. And as a friend of court, I'm going to tell these issues. When it comes to, I'm coming from a civil society organization. The perspective I'm providing is based on the civil society perspective, and it is really focused on the situation of Afghanistan because we have worked with the court through and the victims in Afghanistan. It is not beyond that boundary. The experience actually could be different, but what I have heard from Rohingya, it is exactly same. It's a kind of copy paste. I don't know. I think it was Judge Beatty said that OTP has a copy paste stand when it comes to the respond to the LRV, but when it comes to the situation like Rohingya in Afghanistan, it's also the same copy paste here. Let me start with the information. I can say Afghanistan has been in the ICC investigation or in the ICC proceedings like 16 years. In the 16 years, there is no single document provided by the ICC in the local language or in the language they can understand through the means that the victims has access to that. There might be some documents translated, put it in the ICC website, but I am telling you, Afghans do not access to the internet. And there are the majority of Afghans who does not have the ability to read or to write. So in terms of information and outreach, there is zero outreach and there is zero information. I'm not going to tell how important is outreach and how important is information. I'm telling you that the majority of Afghans and the majority of victims, we have been working for them for years. They even don't know such a court like ICC exists. And now you think that ICC is going to provide justice for those victims. They even don't know that a court exists here. They do not know about their rights, for sure. They do not know what is happening here. And there are also victims who knows a little bit about the ICC, or Afghans, they know a little bit about the ICC, but for sure they do not know exactly what is happening here because there is no information. Since the investigation has been resumed in Afghanistan, that was November 2022. Since then, there is not a single communication or a single information about the stage of the investigation, or the victims have been approached. When I'm talking about the victims, I'm not talking about 1 or 2, 3 victims. I'm talking a group of millions of victims in Afghanistan. You know that Afghanistan situation, the scope of Afghanistan situation is for 20 or 23, 21 years, as it was authorized by the pretrial chamber or by the appeal chamber, let me put it in this word. In the 21 year scope of the situation, that every part of the country have been in conflict, and more than 10 parties, warring parties, have been involved in the conflict. The victims number is also very high. We don't have the exact number, but I can say that it's millions. So in a situation like that, when we're talking about the victims' participation, and when there is no information and outreach, when there is not, let me also put another part here, which is also very relevant about the legal aid. When there is not legal aid provided for the victims, I would like to thank those lawyers who have supported us in the past years, pro bono, and still they are supporting us. But compared to the scale and the gravity of the crimes and the victims we have in Afghanistan, this illegal aid we have received, that is not from the court, of course, that's from the individual contact we have had with the lawyers, and it is their support. It is really nothing. It's really nothing. And
can I ask you, what impact has that had in how the court has been seen?
exactly, that was. I'm going to also with this gap, and the reason we are saying we are not happy, the impact we are seeing. There is misinformation about the court. Especially, there are some media still providing information recently about the ICC. It is not necessarily about the ICC in Afghanistan, but in general about the ICC. I can clearly see that the information they are providing and the audience is Afghans, that is incorrect about the court. And one of the reasons I can say it is because the Afghan journalists and the Afghan media, they do not have access to the information in their own language. There are a few of them who can understand or read English, or I'm sure there is not much reading the other official language, but at least English. When they do not have access to the right information in their own language, they are giving wrong information to the population. And I'm saying that for organizations like us, the scale and the power we have, correcting a misinformation given by local media is taking years for us to correct that. And unfortunately, right now, that is one of the impact we received due to the lack of information. And I can also see ICC as a beacon of hope for Afghans who knows that. There are Afghans who does not know, but there is still Afghans who knows that. And the expectation they have and the lack of information, lack of correct information, there is not communication between court and the affected community. Their expectation is also high. And when they see that the ICC is going to investigate a few cases, and from that broad scope, they are going to have a very narrow look into the situation, I'm saying that there would be a lot of victims who would be disappointed, and it is creating this mistrust. And at the end of the day, there would be, and still I see there are victims, they are feeling re-victimization. And I'm afraid if the ICC goes in this situation, in this approach related to Afghanistan, with this limited scope of investigation and limited information, the impact of the ICC investigation would not be what it is said in the Rome Statute. It could be against what the ICC Rome Statute is suggesting.
Thank you, Hassan. I hope to be able to come back to you on that second question. Let me turn to Megan now. So, Megan, what have you been missing, and what impact has that had on your work?
I think the people who know me know that I could probably speak about this for 3 hours. The list is a long one of what we are missing as lawyers representing victims, but I've tried to focus on just a couple of things. I've really identified what I think are the 3 biggest problems for the lawyers who try and represent victims. I try and be realistic about what a court like this can offer to LRVs. I have been on the inside of the registry, and I know that there are resource limitations. I know that there are struggles within the registry. So I hope you can see me not as some extremist victims advocate who's coming here to say, I want lots of money, okay? So 3 things that we are really lacking that I think really inhibit our work. And the first one, obviously, no one will be surprised, is legal aid. What does it mean for a victim's lawyers to not have legal aid? It's not that I want lots of money to do this work. Nobody is in this work for the money. I can tell you that Fiona and I, Kate Gibson and other lawyers who do this work, we are more than fueled by our rage. We are, but rage doesn't pay the mortgage, it doesn't pay the rent. So we need some money. And the problem we have is that when there's no legal aid, we are very busy trying to find other paid work, and we don't have the time to give to our clients that we need. And it's beyond that. We need to pay to do this work. I need to pay to go and meet my clients in Bangladesh. I need to pay every time I contact them because I need to pay an interpreter. Okay, so I am spending money to do this work. That is how much rage I have. So legal aid. What does it mean that there is no legal aid currently? You know, when we tried to organize this event, we wanted to have diversity at the front of this room, and we struggled. And I really believe part of the reason we are struggling is because there aren't that many people who can spend their own money to do this work. You need to be a pretty privileged person to do this. The second thing, aside from money, because I can go begging foundations and donors to give me money, it's not very successful so far, unfortunately, but I can try and get money from other sources. But there are some things that you can't get from another source. Nobody but the ICC can give me a letter attesting to my privileges and immunities, right? Nobody but the ICC can communicate on my behalf with a state party to get me access to a refugee camp or to get me a visa. There are many sorts of services which we need from the registry, and at the moment there isn't a system for that. And just to give you one concrete example, everything at this court works electronically, right? What do you need to make that work? You need an ICC email address. None of us have ICC email addresses. So if I want to do a filing to the registry, I need to send it from my own personal email address. I can't use the electronic filing system of the registry. I do a confidential filing to the registry. I have to send it by email, unsecured, from my personal email account. And then the registry, if I'm lucky, because it doesn't always happen, will notify me of that filing in a protected email with a password. And they're doing what they can. I don't blame the people in CMS for this, but it's a bit of a joke because my information has already gone unencrypted from my personal email to the court. And then I just have the additional struggle of trying to open the encrypted password protected thing that comes back to me. Now, half the time we don't even get the notifications. If the prosecution decides that they don't want to put me on the notification page of their filing, it just doesn't come to me. Last year we did some filings and the prosecution didn't put us on the notification page of their response to our filing. We didn't get it. So there are so many barriers which stop us from participating in the proceedings in this way. That's the second thing, those basic services which only the registry can provide to us. And maybe I can come back to the things that we are doing through the ICCBA in collaboration with CSS to try and address that. I want to acknowledge that there are some processes in play to try and address these things.
Maybe you could turn then to maybe some more of the actual impact.
Can I say one last thing very quickly? In order to even ask for these things, you need information, right? Now, I have a lot of information because I used to work in this building. I have a lot of information because I know the people who work in CSS and I can ask for it. It's not only the victims. We've heard from Ihsan and Jimena about how the victims don't have information. LRVs also don't have information. Most of them don't even know to ask for an email address. Most of them don't even know to ask for a letter attesting to privileges and immunities. So information is also really important. I could go on about information from the OTP, but maybe we could come back to that. Impact. The impact, you know, we were talking earlier about standing, and standing is the big theoretical barrier to victims being heard when we are told we don't have standing. But even if the court accepts that we have standing, we still need all these practical things in order to be heard as lawyers. And I was really grateful for what Gilbert said earlier about what happened in Rome, even though my own government, Australia, was not very constructive at that point in time, about the fact that those who opposed victim participation wanted to do it by saying victims couldn't have lawyers. Victim participation is victim representation. Nobody can participate in legal proceedings of this complexity without a lawyer. We don't allow defendants to do it. Why would we ask victims to participate without a lawyer? So everything that the court is doing that doesn't support legal representation, that is a barrier to participation.
I wish I could say that I had something different to say, but I'm afraid the short answer again is no. We haven't had the services that we need to do our work. So the first problem is, yeah, you're not notified of things. You have to go to the website. You have to find out, like anybody else from the media, what developments are happening. You don't know really even how to access the building. So my colleague said, well, I heard that there was a room for LRVs, but I had no idea how to access it. It's basically an overwhelming sense of being lost in the chaos of the registry. So it's really not clear where to go for what. If you want to access the building, if you want documents, if you want to know anything, you don't know who to ask. And that comes back to what Megan said. You know, she would have a better sense, I would have had a better sense. But a new LRV who hasn't had the sort of insider experience that we have, for them, it's all opaque. It's really not clear who to go to for what. So they, you know, you have a sense that you don't really have any status at all. And the impact, you're on your own. You do everything yourself. Work it out. Legal aid. Indeed, the team had been told from the beginning in 2020 that there wasn't going to be any legal aid available. I understand that there is now in the new legal aid policy some provision for legal aid at the during the investigation stage. And we can maybe talk about that later. But really, just along the same lines as what's been said, how can you have effective legal representation if there's no opportunity for such for support of any kind? I'm going to talk a little bit about public information and outreach to victims. During the last couple of years, we met with quite a lot of victims in Palestine, and we asked each of them, have you heard or seen any information emanating from the court about what's happening, about, first of all, the preliminary examination, but then the investigation? Not a single person, not a single victim said that they had seen any such information, so rather similar to what Hassan said. And they told us that they feel overwhelmingly a sense of complete absence of the court. They feel abandoned by the court. They have no reassurance that the court is doing anything. And I know that the registry is doing some things in terms of public information and outreach, but it's just not reaching people. And there are really important messages to be conveying during an investigation. One of them is just the very fact that details of investigations will be confidential. And if you think about it, you know, that would make sense to most people. If you explain why, you can't give them details of how you're investigating. But just to explain that, explain what's going on. Very importantly, tell victims how they can submit information if they want to. Explain the fact that everything may take a long time and any opportunities victims might have to participate. These are just some of the things that it's really important to convey. Since October last year, since the crisis, the recent crisis erupted in Palestine, of course, there have been occasional statements by the prosecutor, but that is not and that cannot replace public information and outreach that the court should be doing. There's no context for it. People can't really understand it without the wider work that's necessary. So since October, people have been telling us that they're losing faith in justice and in the court. And this is just, what's happened since October has just deepened the sense of a lack of tangible awareness of the court. And one thing I would say is that that faith, once lost, is very difficult to recover. And unusually, as many of you will know, in the Palestine situation, there is actually an order of the pretrial chamber to the registry to establish a system of public information and outreach. And, you know, to bring this back to the subject of this afternoon, the chamber, in issuing that order, was really clear about the link between provision of information to victims and their ability to play a role in the proceedings. So in addition to all the other reasons that many of which we've already heard about today as to why public information and outreach is really important, it's fundamental if victims are going to be able to play an effective role in the proceedings. And I have to say that the reports that we see every 3 months, the registry was ordered to report every 3 months on its implementation of this order of the Chamber from 2018. And these reports have frankly been very disappointing. They've time and time again, I think always, each one has said that in terms of public information and outreach, that activities have been very limited due to lack of resources. We'll come to that, I know, later. COVID restrictions, security situation. So there's always a reason, but there isn't really any more, anything to give people some hope that something might change and that more might be done. And there's no excuse in the sense that the court and states have been reminded time and time again of the importance of early information and outreach to victims and early legal representation to ensure victim participation. It'll take too long to go through them, but just to say, for example, the independent expert review in 2021 commented on that with strong language. And I was actually shocked to rediscover that every year from 2010 onwards, as part of its annual resolution on strengthening the court, the ASP passes a resolution that says that states emphasize the need for the court to implement the court's strategic plan for outreach, including by early outreach from the onset of the court's involvement. So that's the resolution that's passed every year by states parties.
Great, thank you. Okay, Fiona, what are you going to do to fix this? Or what do you think should be done? I mean, is it just a matter of throwing some money at it? Or is it deeper than that? Do we need different policies? You know, how do we fix it?
Maybe I should start by sort of saying, how do we get here? Was it always like this? How has this changed over the years? I was at the court in the early years. So what has been the longer term view of this? I would say that the limitations on what the registry is doing have sort of crystallized over time. Early on, it wasn't really clear. Of course, everybody was waiting to see what the chambers were going to say about the role of victims in the proceedings and really to work out what was expected of the registry, especially since this was quite new, as we heard this morning, a new aspect, a new element of international criminal justice. And it's in the early days, I would say that the registry did do more. There was public information and outreach to victims and affected communities before cases were opened. There were seminars for lawyers. There were support when the legal representatives came to the court. But it's true to say that there were only 2 situations in the beginning. The number of investigations increased, cases started, demands grew. And the way I remember it, the registry initially made some effort to say, well, look, this is what we should always do in each situation, and we'll need these resources to do it. But then over time, the registry seemed to kind of give up and stop making those strong efforts to explain what was necessary and why, and to ask for the resources. And so it sort of hardened into this internal policy that said, well, nothing much can be done. We can't do anything until really a suspect is before the court. I would say some things have been more restricted from the beginning, such as the provision of legal aid at the early stages. Do you want me to move on to what, sorry, I'm talking a lot. Shall I move on to what can be done about it? Well, I think the first really important point to make is that this limitation that has emerged and sort of hardened over time that I mentioned is really largely based on the registry's own interpretation of its mandate and does not come from the limitations imposed by the legal framework. I don't see.
Can I check? Are you saying that it depends on the individual registrar, or where does that come from?
Where it comes from, I think, maybe I'll come to that a bit, but I think, so if you look at the documents describing the registry's role, you just don't see anything that supports that approach. Indeed, the opposite. So, for example, regulations of the court Regulation 5 bis. Outreach programs shall be aimed at making the court's judicial proceedings accessible to those communities affected by the situations and cases before the court. Rule 92 on notification, I think, has already been mentioned. I mean, I would certainly argue that the order of the chamber to the registry to provide information and outreach imposes an obligation, or raises the obligation under Rule 92.8. Don't want to get into the weeds here, but to provide notification. So the registry is imposing limits on itself, which in a way should be good news, because you think, well, maybe it can more easily be changed. Where there's a will, there's a way. But these limitations now are sort of assumed, and they underlie, for example, registry proposals to states parties on the new legal aid policy, its annual budget requests. They're all now sort of premised on the assumption that there are these limitations. Now, of course, the registry is dependent on decisions of others, by state parties in particular, on resources. But it is initially up to the registry to articulate how it sees its obligations and what it needs to ask for those resources. I would argue that there are more things the registry can do to try to have access to resources to do what it needs, rather than just saying, well, we need to add to the annual budget. I think there are more creative ways that it could do that. Because I do understand the concern. The registry does not currently have the resources to do all these things. And there is a real concern about, if you like, opening the floodgates with so many cases and situations. If you said, yes, legal aid for all at the situation stage. So of course you have to have some parameters, but I think it's doable. At one time said it wasn't really possible. It was said, well, it isn't really possible to organise for thousands of victims to participate in proceedings. Well, look, a way was found. So I do think it comes down to where there's a will, there's a way. I think in terms of concrete suggestions, it would be really helpful to have a statement from the registrar expressing a commitment to sit down and talk about these issues. I understand that, Megan, you mentioned that there's has been a proposal put forward, but I think it would be helpful to have a commitment to do that. On legal aid, I see the new policy. I see there's a joint committee on legal aid that's supposed to be established. I think that body, or some body, needs to come up with a framework for implementing this new provision on the lump sum for LRVs during the situation stage, and that should be made known transparently to LRVs, so everyone knows where they stand and what they can request and what they can't. And yeah, on public information and outreach, I think there is more that can be done with existing resources. I think the registry can sometimes be a bit more assertive with the OTP when it comes to what it does on outreach and public information. And as I say, it certainly can be more assertive in making arguments to states and trying to raise the funds. Just sort of final thought, when I hear constantly the rhetoric from court representatives saying it's all for the victims, this is a victims' court, victim-centered court, I always think to myself, it's really not good enough to say that, but at the same time, not really be interested to know what victims really think and what they want. And it sounds increasingly hollow in situation after situation, as we hear that victims are disillusioned, they're frustrated with the court. And as I've been trying to convey, I do think that the registry has its role to play in that.
Yeah, I think Fiona's really mentioned some of the practical things from the ICCBA side, and I think the last few years have been a really positive development for council, because we have now an association for council which also represents Victims Council, and Marie-Hélène, our current president, has really been tireless in supporting Victims Council. And one of the things that we have initiated is a discussion with the registry precisely on these issues of services to Victims Council, and also on legal aid. And I think it's really through those efforts of the ICCBA that we finally got a recognition in the new legal aid policy that there should be at least some legal aid at this stage. Now, right now, the allocation is €30,000 for the entire situation, no matter how long it lasts. So my efforts to work out how the number was right,
30,000 for
the entire situation, any situation.
any situation. Okay.
It's not clear. There's 3 paragraphs in there. It's not clear how that will be divided up between different counsel or whether the registry envisages one counsel representing all victims, even if they come from different conflicting ethnic groups. None of that is clear. There's a lot to work out, but I will say it's massive progress that we have it in there. People who are nerdy followers of the court might have seen my futile attempt to get legal aid in the Bangladesh-Myanmar situation last year, and I was basically told, you're not a legal representative of victims because the chambers haven't appointed you. So I don't know what's happened to Rule 90, paragraph 1, that says that victims choose their lawyers, and we also haven't had a process of victims' counsel being chosen. So there've been a lot of barriers, basically, is what I'm saying, and we have made some progress because we now have a recognition in principle of legal aid that needs to be improved. And the second thing the ICCBA has done is to propose a protocol to the registry that would regulate these non-legal aid services, you know, IT services, access to the building, these sorts of things. So I hope the registry can progress those things. I think on a bigger level, what it requires is a willingness from the registry to tackle these issues, to not be scared of the floodgates. We need to stop saying the word floodgates. As Fiona said, there are solutions. There are solutions in the legal texts, you know. I just mentioned Rule 90, paragraph 1. There is Rule 90, paragraph 2 and 3. If it came to it, we could impose common legal representation if the concern was that there are just too many victims' lawyers coming forward to do this work. You know, but really we need to sit down and stop being scared to address these issues. I also want to say, I don't believe, maybe this is controversial, I don't believe the solution lies in the OPCV. Jimena mentioned it before. The OPCV is swamped trying to do the work that it's already doing in multiple cases. And I think those who were following when the Ongwen case started, and there was some litigation around what the OPCV had managed to do in Uganda in the period since the arrest warrants were issued in the Coney and Ongwen case. Because the OPCV was appointed in that situation as well as in the case. And in the intervening years, while nothing happened in Uganda, the OPCV didn't go to Uganda. And when they were pressed on it in 2015, they said, we haven't had the resources. So there's sometimes this feeling that we can save some money by using the OPCV. The OPCV is just as expensive. It's actually more expensive than external counsel because they are staff, so they are paid a lot more than we are, right? So the idea that you save money by using the OPCV, all that happens is the OPCV, like everybody else in this building, prioritizes active cases. And the situation victims will be neglected. You need dedicated victims for this situation. So we need to tackle these issues. We need to say, even if these issues are difficult, let's step up and deal with them. And I think, honestly, we need a change in mindset in this institution as a whole, not only in the registry, to think about the situation stage as being crucially important to victims and, frankly, as not being owned by the prosecution. The situation stage, the investigation are not the property of the prosecution. You know, we have allowed prosecution to control everything that happens, not only its internal investigation workings, but when I go to people in the registry and say, what are you doing about this situation? VWS, outreach, very often the answer is, we'll do more when there's an active case. We'll do more when there's a suspect before the court. As Gilbert pointed out, that means most of the victims never get anything from the court. So we need to stop seeing the investigation as owned by the prosecution. We need to remember why this court exists, for whose benefit exists. The prosecution is important. It has a really important role to play. Okay, but it also needs to be accountable to the victims. And we also need to give an opportunity to the victims' voices to be heard. The victims don't only care about what happens in the courtroom during trial. If you were to ask the victims, what is the most important part of this process to you? I guarantee you most of them will say, we care about which case is opened. And we also care about what happens at the end. What is sentencing? What is reparations? And unfortunately, in this court, we are moving towards a position where victims have a little tiny voice during the trial process, but at the beginning, during the investigation, and we saw last week in Katanga at the end during reparations, their legal representation is removed or it is eroded in different ways. So we need to remember why we're here, why this court exists, for whose benefit it exists, and apply that from the very beginning of when the court gets involved right up until the end.
So, Isan, I want to give you the opportunity to answer what you would say practically needs to happen. I just did a back of the envelope, so 30,000 euros. If you'd had 20 years worth of involvement from the ICC, that's 1,500 euros a year. What could you have done with that?
Not much.
Okay, so what would you do?
So from our perspective, looking into the problems as I brought them up, when it comes to the information, and as I said, there is no information. When we approached to the different part of the ICC, when we went to the registry, relevant unit in the registry, first they said they don't have mandate. It was, I'm talking about like before the resumption of the investigation. Of course, we have our disagreement with what they told us, and it was quite tense, the relationship between us and those relevant institute in the registry. And after that, they said that they do not have enough budget. That's why I'm also saying that with the budget given to the relevant registry unit, they also don't have much to do with the investigation. I think they said they have like 1,000 and something for per year, and they have a lot of they have money situation to look into that, and they have to do the prioritization. And this prioritization and deprioritization, when it comes to Afghanistan, actually, it's quite hurting. It is also happening with the situation in the OTP. As you know, that the prosecutor Karim Khan deprioritized many aspects of the investigation when it comes to Afghanistan, and it limited the participation of victims that those allegations have been deprioritized. And also it gives prioritization to the ongoing atrocities, which is also, again, very limited when it comes to the Taliban and ISKP. ISKP is the Islamic State in the Khorasan province, and Karim Khan said that he is going to investigate those allegations against them. It is not all the allegations against the Taliban and ISKP, it's a few of them, and that is really focused on ongoing. Perhaps one of that would be gender persecution. And when we go to the OTP and ask them for information, there's of course using the same court, always using confidentiality. It is confidential. We cannot do that. I think it is really important for the OTP to really come with a framework to protect their confidentiality, at the same time to give there's space for the victims to have access to what they are doing, because whatever they are doing, as our colleagues already said, it really impacts the right of the victims. And based on the ICC and room statute system, whatever is impacting the right of victims, the victims should have this opportunity to know that and to respond to that. OTP should find a way for that. And also, I can understand when it comes to the practicality, Janet, ICC, the expectation from ICC is of course high, and ICC is surrounded by the challenges and constraint. I was also thinking a part of what ICC cannot do when it comes to such a situation like Afghanistan. It's really important that ICC look into the other accountability mechanism outside the ICC, not to ask them to support the ICC investigation per se, or it could be, but somehow to try to have a coordination with the other accountability mechanism. For example, when it comes to Afghanistan, I can name the national inquiry. That could be, I don't know, maybe new term for some, but it is referring to those countries doing inquiry of their own soldiers presented in Afghanistan. For example, the UK has one inquiry, Australia has one, Netherlands had one, and actually the primary court in the Hague convicted one, or at least one, of their soldiers in accusation of committing war crimes in Afghanistan. So this kind of investigation, encouraging these countries to do that, is important. And also cases under UJ, universal jurisdiction, is important. I think it's for the ICC to reach its founding goals, it's important to have a kind of proactive approach, and to try to find other coordination, other mechanisms to coordinate with them, that they somehow can complement what ICC is doing in such a complicated situation like Afghanistan.
I have the privilege of trying to pull together everything we've been talking about today and formulate what I hope will be some concrete recommendations for how we can stop the backslide. I've also had the privilege of appearing before the ICC in 3 cases as defence counsel, one of these cases which lasted for a decade. So I'm very well acquainted with the obstacles that we have encountered as defence teams. And there are many, but we have never encountered this problem of standing, of fighting to be seen and to be heard. And whatever your views are on the defence, you know, we are allowed to be there, we're required to be here. And so coming around and now having this experience of representing victims was an entirely new ballgame to me. The challenge of just trying to be heard, you know, having no clarity whatsoever on what I could do. Could I file? Could I appear? And this is 23 years into the court's operation. It's not a secret, I think, that the original trigger for the idea for today's event was the decision of Pretrial Chamber 1 in November last year in the Bangladesh-Myanmar situation, which Megan has spoken about, which adjudicated a request brought by 3 legal representatives in that situation, including Megan and myself, for the adoption of a protocol to regulate the activities of parties who are acting in the situation phase. It's also not a secret that we were motivated in filing this by some really concrete problems that we were experiencing in relation to our victims in the situation phase. And so we brought this filing. Megan and I had both previously filed before in front of Pretrial Chamber 1, although differently composed with no problems. And when we filed this motion seeking a protocol, we were told, no, you don't have standing, you don't even have the right to file it. So you might be thinking to organise like a 6-hour high-level panel to discuss this is sort of an overreaction to a bad decision. And, you know, we do love to vent on victims' issues, but this is extreme even for us. But of course, the problem is far deeper than that decision in last November. Why has there been this tightening and diminishing of the role of victims in the situation phase? Is this what was actually intended, for victims to be seen and not heard? You know, to be the object of international criminal justice, but not a participant? And if not, how did we end up here? Judge Odio Benito this morning described victims as the primary stakeholders of international justice. Megan talked about them as agents. And surely that's right. And that's what we wanted today, to have a forum to try and engage on these issues and discuss these issues. You know, is our understanding wrong? Have we had this wrong all along? Or is it time to recalibrate? So to try and pull this all together in a semi-objective way, I wanted to just quickly set out what I think we've identified today as the problems, and then turn to what are the concrete recommendations that our speakers have offered to try to fix them. And I think at least we can all agree that our discussion today has demonstrated that not all is well in the state of victims' representation in these early stages. Judge Odio Benito set it out in black and white. There is a backslide. In her view, the latest case law from the court on victims' participation is a step backwards from the goals of Rome. The jurisprudence is becoming more restrictive and limiting the spaces for victims' participation, particularly in the situation phase. What are the obstacles that we've identified today? Access, victims' access to information to allow them to engage with the court. Judge Odio Benito talked about lack of proximity. They're not here, they're not close. It makes it difficult for them not just to be informed about what's happening in the court, but for us to learn and engage with them. And I think Jimena explained this really powerfully in relation to the lack of information being given to victims in Mexico. The victims want to know if things are moving forward, and if not, why not? And that information isn't there. And we also heard from Isan, who explained about how the lack of information impacts on how the entire victim population even views the ICC, and not in a good way. And he raised, importantly, the risks of misinformation spreading in victim communities, which then creates mistrust. We heard about the obstacles of case selection. Judge Beatty gave us this really good example of Lubanga, this first case where we saw an extremely limited group of victims who could participate in Lubanga because the charges were restricted down to this one war crime, the recruitment and use of child soldiers in Aturi, meaning that the vast majority of victims in the DRC were left out. And the result is that the prosecution feels that it doesn't need to engage with all of the victims in the DRC, all the victims of the situation. Rather, they prioritise focusing and engaging with the child soldiers and the victims of those crimes. And so it means that they'll engage with only victims who are supportive of their work, as opposed to the majority of the situation victims. And in terms of the prosecution's position here, which really was a recurring theme today, we heard this in black and white from Judge Beatty, that since the very beginning, the position of the Office of the Prosecutor has been that victims should participate whenever they support the Office of the Prosecutor. So this is the basis for the office's opposition to victims of the situation, which is what we're talking about today, that if victims of the situation are allowed to come before the judges, then they'll have the ability to criticize the charging choices being made, or they'll somehow compromise the investigation. Because as Megan pointed out, the prosecution sees themselves as owning this phase, as owning the investigation. And then to add to this, that the pretrial judges haven't always been consistent to victims being allowed to have a voice in this stage. This idea of the Office of the Prosecutor's opposition to victim participation in the situation was corroborated by Ide, who explained how this plays out practically. She gave us her experience from the Comoros situation, where while victims were allowed to participate in this judicial review process about closing the situation, this was over the objection of the Office of the Prosecutor, who really pushed back on the idea of victims making any submissions on substance, on gravity, on impact of crimes. We heard today about this generally inconsistent approach from the judiciary. We heard from Ide about how victims can be represented in Afghanistan in front of the appeals chamber, but not in front of the pretrial chamber. And we see this ourselves when we read the decisions, that chambers have no problem with reinventing the wheel in every situation. We have no procedural certainty, no legal certainty on this question of participation. And lastly, we heard about funding, resources, the obstacle from which all other obstacles flow. There is a lack of resources to support victims' participation. There's no clear framework for this support, even in the most recent legal aid policy. There are many flow-on effects of this. There's no concrete regime for legal aid. As Megan explained, this means LRVs can't focus exclusively on their clients. They have to get other paid work. They have to pay for themselves to do this work, which means that diversity is nowhere. Who can afford to do this work? People in positions of privilege. We don't have diversity and representation. There's no concrete systems in place for LRVs to get visas, letters about privileges and immunities, an ICC email address to allow us to file documents or to get in the building, to receive filings, or to even get the information that we need to be able to get those things. There's no translation of documents into key languages for victim communities. There's no outreach for victims who can't read or write. We heard from Ihsan about the lack of outreach for victims in Afghanistan. He didn't say insufficient outreach. He said zero outreach. So thank you to our panelists, moderators, for drawing all this out. We're now in a much clearer position about what the obstacles are and what the problems are. What do we do about it? So, solutions. Perhaps first turning to the judges, we heard from Judge Beatty, and frankly, we can see it ourselves in the decisions, that different judges have different positions on this. Some judges are not supportive of victims' participation or standing. What's the solution? I would venture it starts with conversations like this, events like this as the starting point, particularly to try to explain the impact, right? The practical impact of blocking standing. What's the impact of that to victims' communities and ultimately to the credibility of the court? It was very encouraging to see a recent internal session for ICC judges on victims' participation that was organised earlier this year. Perhaps consideration could be given for future sessions to invite experts like the ones we've heard from today and actual LRVs who have experience on a day-to-day basis on what it's like to act before the court. Turning from the judges to the registry, and like Megan, I'd like to acknowledge here the work of CSS and of Marc Dubisson's office and the registry in trying to make concrete improvements. What can be done? The ICCBA has drafted a proposed protocol for services to Victims' Counsel in the situation phase. One concrete recommendation would be for the registry to finalise this and publish it and implement it. or even, as Fiona McKay suggested, just to make a public commitment that the registrar wants to do this. And then to the legal aid policy, which is the bane of those who administer it and the bane of those of us who try to eke out an existence from it. No one wants to talk about it, but here we are. We've heard today overwhelmingly that it's insufficient. Megan told us about an improvement of a certain amount of funds that have been set aside per situation, but it's not enough to fund effective representation. The registry can only work with the budget it gets from states. What can it do? We heard from Fiona McKay about the things the registry could do to fight to increase its budget without opening the dreaded floodgates. I said it just for you. The registry could request a budget from the states for the services that are needed, particularly legal aid and outreach, which are critically underfunded. There's an impasse we see with the registry saying states parties don't fund us and the states parties saying the registry is not asking us for this. And it seems like there's room for movement here. So then to the states parties, we're really pleased to have so many of you joining in person and online. As always, any meaningful improvement at the court starts with states parties. And for victims representation, this means, in plain terms, giving sufficient budgets to support legal aid, outreach, services to victims. And if the states see that this is still underfunded, they can also consider providing funding to victims outside of the court's framework. So directly working with organisations who work with victims or giving money directly to victims' lawyers. Lastly, to the Office of the Prosecutor. The OTP, we've heard from our speakers, opposes victims standing in the situation phase. Judge Beatty suggested that perhaps the prosecution needed training on this, needed better information on this, but then concluded that it isn't a question of training, it's a question of perspective of the Office of the Prosecutor's position on victims and their role. And I certainly don't see it as my role to tell the OTP what position they should adopt, but the Office of the Prosecutor has a significant number of special advisors. They have a special advisor on gender persecution, a special advisor on crimes affecting children, a special advisor on slavery. So a starting point could be for the Office of the Prosecutor to ask these special advisors what they think about victim standing and resources and access and role in the situation phase. Is there a risk that we as an institution are now just acting in the name of victims but without letting them in? And if the Office of the Prosecutor has concrete concerns about risks of victim participation, whatever they are, confidentiality, inefficiency, then we could think about ways that these concerns could be mitigated rather than just this hard line, victims in the situation cannot be part of this. So as we've just hit 5 o'clock, I'll wrap up and say that I think today was really important. The ICC isn't static. It's this growing, volatile, changing institution that we are all really invested in as practitioners, as CSOs, as members of civil society, as states parties, as staff. And when we see things going wrong, we have an obligation to come together as the supporters and proponents of the court and talk about it and try to find solutions. And we heard from Fiona McKay that victims in Palestine have felt abandoned by the court, which is so awful to hear because that's the absolute worst outcome, right? That's exactly the opposite of what any of us should be doing in this building. And this is what collectively we need to try and avoid. So we're really grateful to you for having come and given us an afternoon to be part of this discussion. But we're counting on you to continue these discussions in your various roles as we continue on our quest to try and formalise and provide some uniformity to the participation of victims, to make sure that victims aren't just relegated to the objects of ICL without a meaningful voice.